Hi everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So I'm logged into my YouTube and I'm gonna look at your comments, what you guys have said over the last few days, and I'm gonna answer the questions. So the first question is actually from 650 Tony D. And he says, is there any way I can chat with you about a case? Yes, absolutely. Just text me 347-566-9595. Just text me your name, a little bit about the brief facts of what happened, just so I could have a picture of it in my mind, like, of it happening, like the crash or the fall or whatever your case is about. And then tell me a little bit about the injury, the main diagnosis, whether you had surgery. Tell me the date of the incident. Tell me the city you're in. And that's pretty much it. And then we could schedule a mutually convenient time to chat. And I've been doing those. I did a few this week, and I think it's been helpful. Actually, sometimes I chat with people and I see that they really do need help because either they have no lawyer or they have the wrong attorney, not a real trial attorney. And then after chatting with them, I offer them some guidance. And if they need help, I even give them like a local attorney in their city. And then sometimes they go ahead and they use that attorney, and then, completely changes the case. Like I had situations where somebody was represented by like one of these billboard lawyers and they were going nowhere and the guy wasn't even filing a lawsuit. And I changed it. I gave them like a real trucking attorney. And then I hear a few months later, hey, that case settled for $3 million. Well, I was glad that I was able to help them, because they were on a path to nowhere and now they're on a path to success, and, they actually achieved success. So that's what it's all about. So it's all about helping people and helping serious injury victims and families. And here's a comment in response to this video I did about the unwinnable case and how an unwinnable case became a record victory. That case was about a kid was driving a car, but he only had a permit, and he hit a pedestrian and killed the pedestrian. I think the pedestrian was another student, and the kid with the permit was also a student driving to school, but he shouldn't have been driving on his own because he only had a permit, not a license. But anyway, they thought it was an unwinnable case because they said, look, you could just sue the kid and the kid has limited insurance. But the lawyer sued the city because they were supposed to put in sidewalks and they chose not to put in sidewalks. They used the budget for something else. And, he said, well, if you put in sidewalks, that would be a barrier because you were walking above, you have a curb, would have prevented this. And the jury agreed and they returned a verdict of $38 million. And so the question is, did the presiding judge lower the amount? No, the presiding judge did not lower the amount. I don't believe the presiding judge can lower. I guess they can lower the amount. Depends on what venue you're in. This was in California, I believe. So out there, maybe the judges, I think they do it through an appeals process. And then he also asked, is it still in the appeals and was it vacated and returned to the lower court? I don't think it was vacated. I have to ask the attorney, actually. I have to research with the attorney, because the way I learned about this case was I didn't study the full case. I don't have like the full transcripts. I could maybe get them because I'm friendly with the attorney who tried it. I know the guy, he's a very good lawyer. I could maybe try to get it. But the reason I talked about this, because he did a continuing legal education presentation where he talked about a lot of cases. I think he talked about like 20 cases, and he said these are like the frames. It was about framing and how to frame your case for success. So that was just one of the cases. So he only talked about this case for like 5 minutes. So I don't know exactly, but I could maybe try to find out. So I'll look into that. And then Reginald says, do you allow the defendant attorney to continue cases if they had plenty of time to prepare? I feel the defendant attorney is delaying my case by asking for a continuance. They had all the information for 9 months, but they are now asking for more time to secure an expert. It's so frustrating, so frustrating. Yeah, I would say no, I don't do that. I wouldn't allow that, never allow it. It's just, fight them on it and say, look, you have a court order, there's no reason for this, let's get a trial date, just push the case. And then if the judge gives them an adjournment or a continuance, one time, but then let the judge know that you object to it and explain the reasons that they had time, there's no reason for this. And then look, if the judge gives them one more chance, maybe like another month or another short adjournment, like 30, 60 days, then, that'll be the final one, and then you'll have your trial, because you don't want to just say nothing or just kind of like be lazy on it, because then the judge will think you're okay with it. Okay, I'll give him one adjournment, I'll give him a second adjournment, and then they keep asking for that, and then they could delay the case indefinitely, and that's not good. So yeah, you have to fight that. And then Gio Mendez says, very good information. I have messaged you a while back and received new information. I was rear-ended by a commercial 4x4 pickup truck over 2 years ago with a $5 million policy limit. And now my CMC is less than 2 weeks away, and they have accepted full liability and have proof of statements and the police report. They have sent a first offer of $80K, but my medical bills are $50K and the lawyer fee is 40%. So we denied that offer. I just want to know what from your experience will happen, and notice I was 20 years old at the time and now I'm 22. Yeah, I mean, it's best to text me again and we could chat again. It's hard for me to say because I understand, they accept liability for the happening of the incident, but they could still fight you on damages if they're only offering $80K. I don't know what your full injuries are. If you have like surgeries, depending on where the case is venued, the location. If you have surgeries and you have a life-changing injury, I think it's way too low. It should be much higher. It should be in the 6 figures, maybe even in the 7 figures, more than $1 million, if you have surgeries. So I'm happy to chat again. I don't recognize, because it's the the YouTube username, it's not the actual name, so I don't recognize, I'll remember who it is, but I might probably, if we chatted like on the chat, probably I still have your information in my phone, so I could read the chat again and we could chat, and it's all confidential, and I'm happy to do it. And then Reginald says, so you must overcome doubts with objective findings and experts to confirm your pain. The jury must see objective findings to bring validation to your claims. Experts bring the jury to your side. Family and friends show your before and after. Yes, my body hurts. It means I can still work and move, but my body hurts me means my body is affecting me. I may not be able to go to work. It's affecting my every thought. Yeah, absolutely, absolutely. So you want to have both. You want to have objective evidence, meaning you have like diagnostic testing, like the MRI, because that's going to show like what the injury is, like the herniation, for example. You want to have EMG, because that's going to be like the electromagnetic, EMG, NCV, the nerve conduction velocity. It's actually showing how the pain is moving, right? It's radiculopathy, it's radiating pain. So if it's moving from the neck to the arms, let's say, if you just say it's moving from the neck to the arms, okay, it's your subjective feeling that it's happening, and then the jury has to believe you, as opposed to think, well, this guy's just a malingerer, right? He's making this up in order to get paid. But if you have the NCV test, the nerve conduction velocity, and the EMG, you can't really make that up, right? I could say, I have pain, I don't have pain, it doesn't matter. If it's an objective test, they listen to the fibrillation potentials. They listen to the sound waves. They see the fibrillation potentials. Like, it's objective. It's the actual nerve being tested through the electricity. So if it says that you do have radiculopathy, that's objective. So that's very good to do. All the tests, depending on what doctors recommend for you. And then having before and after witnesses, I really recommend as well, especially those before and after or community witnesses that don't have, a stake in the game kind of thing. If you have like your wife or your husband, okay, but they're also interested, right? Because if you get paid, they're gonna get paid. But you want people who are maybe like your coworkers, people who are independent, truly independent. That's always good. But you're right. The fact that you can't work and it's affecting your every thought, of course, because if someone is in serious pain, it's always affecting you. And it kind of reminds me of this one book I read where the author said, to have pain is to have certainty, but to hear about pain is to have doubt. So it's like we each can have pain and we know what it's like, right? Because we've all experienced it, and it's very certain feeling. But when you hear about, for whatever reason, I don't know why, but when you hear about pain, it starts bringing up doubt, but then it's almost like it shouldn't be. Ricey says, Arkady, Hallmark National Casualty Insurance, how are they? I haven't had too many cases with them. I don't believe they write policies in New York, but all insurance companies are pretty much the same. The only question when people say like, how are they, The only real difference is going to be whether or not they settle for a good number quickly. But if you want to get like paid, you just have to prepare the case for trial, have a trial lawyer. And then when you're preparing the case for trial and the case is moving towards trial, that's the best way to get them to pay the top number. The other difference is some insurance companies might hire like a lawyer that's going to be more like tougher, right? And just ask for a lot of things, authorizations, bother you, make motions. Whereas a lot of the companies maybe hire a defense firm that just kind of, does something, of course, but just does the kind of the minimum and kind of sleeps through the case. So it just depends on that. But I'm not familiar with that company because I don't think they write policies in New York, but I wouldn't really worry about it. I think you should be fine. Oh, then the other part of it is you have to make sure that they have sufficient policy limits, right? You want to find out what's the primary, what's the excess umbrella. That's critical because if they don't have the insurance limits, then obviously you can't get the money because it just isn't there. And then Arash says, if a guy gets 3 epidural steroid injections, would his case be valued at 2.7 million? Loss of enjoyment of life, stuff like that, or that's too much to ask? I mean, from what I've seen, like epidurals are usually not by themselves, are not really worth that much because they're just temporary pain relief. So usually like epidurals, people sell them for even like 20,000. But of course, like if someone has a life-changing forever injury and they have future medical costs, if they have lost wages, if they have pain and suffering, when you add it all together, it could be 2.7 million. But usually those are cases more with like a back surgery, more involved cases. But it's not like impossible to get a number like that, even on a soft tissue case without surgery, but you would have to try the case and have strong proof and be able to persuade a jury of that. It also depends on where and how likable the plaintiff is and the overall proof you have of damages. But it's definitely not, statistically, it's not what I've been seeing in terms of the averages. And then Judy says again about the fall, my lawsuit has been going on for 1 year and 10 months. Does this mean more or less in compensation? My injuries are very serious. I'll never get better, and now I'm going to be using a walker. No, I'm very sorry to hear that. I mean, the length of the case can mean that, it's going to be worth more if that's the issue in the case, right? There could be a lot of things. There could be a lot of reasons why it's going slowly. It could be because your lawyer's trying to get a really big amount and they don't want to pay that amount. So you have to go through the whole discovery process with depositions and documents. It could be there's motion practice. There's just so many possibilities that I couldn't tell you. It's best to ask your lawyer, or if you wanted a consultation with me about like the value of the case or what's happening with it, just text me. Like I said, the 347-566-9595. But yeah, the length of the case could mean the defendant is not offering enough money, so your lawyers are pushing it to trial. But that's just one possibility. It could also be that, the lawyer is busy and isn't doing what they're supposed to do, or is not giving the defendant the proper discovery, and then the defendant is making a motion to dismiss, and now your lawyer is defending a motion not to have it dismissed, right? There's so many possibilities, so it's hard for me to say. And then Thanos says, this is an odd question, but what happens if the defendants don't pay up after the verdict is decided against them? Will the court sanction the defendants somehow, or will they be subject to losing their medical license? I'm just curious, what teeth does the decision hold? Thanks for any response. Have you ever seen the defendants just not pay? So yeah, in New York, we have like a CPLR, the Civil Practice Law and Rules. So if they don't pay, you can file a motion to enforce the judgment or settlement. And so they cannot just not pay, right? It's an enforceable settlement or an enforceable judgment. So you could enter a judgment, and then, once you enter a judgment, you just start collection procedures. You go to their banks, you start withdrawing money from their banks, and they're not going to like not pay because they're basically insurance companies. If there's insurance and they have a lot of money, so they're going to pay whatever they agreed to pay in a settlement. So no, I haven't really seen it. I did have a case like a long time ago where we settled and we just didn't get the payment timely, so we had to file one of those motions to enforce, but then they paid. The Valley says, hello, what does it mean when the plaintiff's attorney files a request for entry of default judgment only? Defendants did not answer the lawsuit on time. Yeah, so that's what happens. Basically, if you file the lawsuit, then your process server serves the lawsuit, brings the actual lawsuit and gives it to all the defendants. But then, they have 30 days to answer and appear and then file it's known as a responsive pleading, right? Because they're filing their document, answering the lawsuit and appearing in the case. But if they don't file anything, then you have a default because they were supposed to file and they defaulted by not doing anything. So then you file a default judgment and you say, look, because they didn't answer, I want a judgment on default. And that's exactly what it is. It's just you get a judgment because they didn't appear, they didn't answer, they didn't do anything. And then you get that. But then the problem with that is then they might later try to vacate the default, right? And then they could try to interpose an answer. So if there is insurance, you might want to agree to vacate the default to have the insurance step in because that's real actual money, as opposed to having like a paper judgment against some defendant. If they're hard to collect on and they don't have any money, you don't want a paper judgment because it doesn't really help. Come Along with Uncle Joe says, what if your case has been going for 3 years and due to the fires, the other side is filing bankruptcy? Does that mean you're not going to get anything if they are self-insured in California? Well, I mean, yeah, that's tough. Usually with a bankruptcy, you have to see what the bankruptcy court does and you become one of the creditors. So if they have insurance, by the way, you can just go after the insurance. That doesn't change. The company filing bankruptcy doesn't matter. But if they're self-insured and they're paying out of their own pocket, then you file a proof of claim and become one of the creditors. And then depending on how much they have left, you might only get pennies on the dollar, unfortunately. Here's a question. E.S. Said says, hello, Mr. Frekhtman. What happens after a plaintiff lawyer gets a defendant deposition transcript? Yeah, so once you get the defendant deposition transcript, you have to see if there are any additional depositions you want to conduct, right? If you're satisfied with the transcript, if you made out liability, if you proved what you have to prove, then you could say, okay, that's all I need. But so you put the transcript in your file, it's good to summarize the transcript, things like that. But then the real decision is, do I want more witnesses? Do I want additional depositions? And then once you have all the proof, then you can say, okay, I have enough. I'm going to certify it as trial ready, file the note of issue, and then you have a trial date. But that's a good sign. It means the case is moving along. Giovanni says, hi, Arkady. With a malpractice lawsuit, can their employees treat you differently because of the lawsuit? Or will I have to move to another hospital? I mean, usually they shouldn't treat you differently, but if they find out, if it's like a big case or it's a small like hospital or clinic and they find out, I suppose they could, if you would have to answer that, right? If you go back there and you feel comfortable and everything's the same, you can continue treating there if you want to. But if you see, hey, wait a minute, I feel different, they're treating me differently, they're not being nice to me, you could always find another provider. And then Andre says, how would someone get more for their claim if, say, for instance, they both had the same procedure? Yeah, so I think like by showing the overall impact to your life, right, and how it's affected or damaged you, because you could have one person having, let's say, a procedure like a discectomy and someone else has a discectomy, but if one person has a discectomy and goes back to work and nothing really changes or he's not able to convey how it affected his life, whereas the other person doesn't go to work or can't do the things he loves and could really tell a story that's like powerful, right? You're evoking feelings and emotions. Then, at trial, the jury will give more money to the person whose life they see changed. Emmy says, I saw your short and I'm the lady that has been writing to you about my lawyer's unprofessional and rude behavior during my 3-year ongoing personal injury case. My main concern is that I'm not sure he is capable. He may be different with negotiating, but after my conversation with him on the phone, I thought he may have Asperger's syndrome. How does an attorney get on the phone without saying hello and hangs up without saying goodbye? The case will be going to the discovery phase on February 11th, and since I recently found your wonderful channel, have been watching many of your videos, I am still struggling as to changing lawyers. I am 81 and not sure how long a time a change with a reputable attorney would take. Oh yeah, no, I'm sorry you're going through that. That's terrible if the lawyer is so rude. But yeah, just feel free to text me or, 347-566-9595. I'm happy to speak with you, maybe help you in any way I can. But yeah, I mean, changing attorneys, if you decide that you're not happy with your attorney, if he's not capable, if he's just rude like that and not speaking with you, it doesn't take too long. Basically, you hire the new lawyer sends a letter to the old lawyer gets a little time, like a few days, maybe a week, to just send their expenses, what they spent. The new lawyer pays those expenses, and then the old lawyer sends the file over. And then the division of the legal fee, how much each lawyer is going to get, is at the end of the case when the case is settled. So say, for example, the case settles for $1 million. Well, you're still going to get the $700,000, which is your client piece of the pie. And then the $300, that's the legal fee, gets shared by the first and the second lawyer. So it doesn't really affect you. So because it doesn't affect you, right, it's in your best interest to get the best possible lawyer, because the best possible lawyer will get you the most money. And then the way they get paid doesn't affect you. Whether you had one lawyer, the first lawyer would just take the full 300, right? If you have two, they just share the 300. So the first one still gets paid. He'll get maybe like 100. And then the new one, if he does a little more work, will get 200 or 150. However they, split it up amongst themselves. It doesn't really affect you. DeValley says, hello, does the plaintiff's lawyer have to wait for the defendant to answer a lawsuit before they ask for any evidence? Yeah, I mean, if it's evidence that's part of the discovery process, then yes, because they would be the ones that you're asking, right? So it depends on what evidence you're talking about. If it's like objective evidence, right, that you can get from other sources, like if there's third-party witnesses, you could go ahead and speak to them. But if it's evidence from the defendant that you would have to get through discovery, meaning you serve a demand on them and you want them to respond in writing to your questions or documents or taking depositions of the defendant, of course you need them to answer, because if they're not in the case, you can't get the discovery from them. But you can get discovery from other sources like FOIL, the Freedom of Information Law. For example, if there's like police video, surveillance footage of a crash, you can get that from the police department, right? For example, and that's not the defendant, and that's separate from, that's known as third-party discovery. That you could get without waiting for them to answer. Okay, I hope this was helpful. Let us know what other questions you have. We are here for you. Our goal is helping serious injury victims and families. All the best, everyone. Have a great day.